misrepresentation and non-disclosure. This is a problem with the process, the formation of the agreement, which is the failure of, which is lack of true mutual assent to the world in which we have agreed upon. Misrepresentation in contract. So there's different elements in contract than in torts, but they're close. So in contract, it's assertion that is not in accord with the facts. Assertion must be fraudulent or material in contract. So fraudulent or, hey, it was a material fact that was not in accord with the facts. The assertion must be relied upon by the recipient in manifesting assent, and reliance of the recipient must be justified. This is different from misrepresentation in tort. The elements of misrepresentation as a tort claim is a misrepresentation with knowledge of its falsity, with the intent to induce another's reliance on the misrepresentation, justifiable reliance resulting in damage. So tort is you have an intent there, and in contract you don't necessarily. You just have an assertion that isn't in accord with the facts, that is material. It might be fraudulent, but it could also just be material, and that is relied on and justified in its reliance. So key differences: nature of misrepresentation. Contract misrepresentation must be either fraudulent or material. In tort, it has to be both. Damages. Contract. Victim of misrepresentation may seek rescission, which is the unwinding of the deal of the contract. So the contract is voidable. Tort. Victim may seek damages for pecuniary losses, including the difference between the value of what he has received in the transaction and its purchase price, or other value given for it, and 2, the pecuniary loss suffered otherwise as a consequence of the recipient's reliance upon the misrepresentation. So misrepresentation in contract is voidable, and you can get rescission. I'll keep going. Misrepresentation. I just want to ask about that, but we may talk about it anyway. I don't want to even say it because I listen to old ones that I've fixed and I'm like, oh, okay. Anyway, so your damages is rescission, unwinding of the deal. If it is fraudulent, Restatement 162 says when a misrepresentation is fraudulent or material. A misrepresentation is fraudulent if the maker intends his assertion to induce a party to manifest his assent, and the maker knows or believes that the assertion is not in accord with the facts, or does not have the confidence that he states or implies in the truth of the assertion, or knows that he does not have the basis that he states or implies for the assertion. So he knows it's wrong. He's not sure, but he sure does give confidence that it's right, or he knows that the basis is wrong. And then material is also in 162, and that is a misrepresentation is material if it would be likely to induce a reasonable person to manifest his assent, or if the maker knows that it would be likely to induce the recipient to do so. So without which we wouldn't have made the deal. Can opinions be misrepresentations? The classical rule is a statement of opinion cannot be fraudulent, but the modern rule says the state of mind as a fact. So a person's state of mind is a fact, and an assertion of one's opinion or intention, including an intention to perform a promise, is a misrepresentation if the state of mind is other than asserted. So it's just a piece of evidence in the totality of circumstances. Seister v. Banta. This is the ballroom dancing case. And how did Seister satisfy the element of misrepresentation? Was there a false assertion? Yes. So Seister was told that she could be a professional dancer. Was it material or fraudulent? Dance instructors told Seister that she could be a professional dancer so that she would purchase more hours at the dance studio, even though she knew she would never be a professional dancer, even though they knew she would never be a professional dancer. So yes, it was fraudulent and material because she was taking classes to become a professional dancer. It was the inducement of the contract. Reliance. Seister bought the hours because of the misrepresentations made by the dance instructors. Reliance was justified. Hard to find justifiable reliance. Like, was she that delusional? Like, honestly, lonely people who get some... It's sad, but can we say it's not like a normal thing? In which case, if it's normal, shouldn't we say it's justified? Don't go down these paths, people. Are there any other doctrines Seister may have used to avoid the contract? Possibly undue influence. But since it was material and fraudulent, she can sue in tort, which means she can get damages. Oop. I am running out of power. I'm not sure I'm going to make it through this video, in which case you're not going to see it. But this will be our last one for now, because I don't have a cord with me. Misrepresentation, alternative methods of satisfying false assertion requirement. Concealment. So restatement 160, action intended or known to be likely to prevent another from learning a fact is equivalent to an assertion that the fact does not exist. So if you conceal it, it's like lying to say it doesn't exist. Example, A, seeking to induce B to make a contract to buy his house, paints the basement floor in order to prevent B from discovering the cracks in the foundation. B is prevented from discovering the defect and makes the contract. Is this contract voidable? The answer, the concealment is equivalent to an assertion that the foundation is not cracked, and this assertion is misrepresentation. However, whether the contract is voidable depends on whether the other elements of misrepresentation are present, which would be assertion that is not in accord with facts. Well, that we just said the concealment is an assertion. It's fraudulent or material. Cracks in the foundation is most likely material, and it was done to specifically so he wouldn't, so it is fraudulent. Is the assertion relied upon by a recipient in manifesting assent? Were there other things? Did they have an inspection? Were there other ways to know? Reliance of the recipient must be justified. So what's normal in that circumstance? Is it just cracks in the basement floor? Okay. Non-disclosure, classically, no. Restatement says maybe. So classic approach says a party to a business transaction could not avoid the transaction because of non-disclosure of material information by the other party. So caveat emptor. So we have concealment, and then we have non-disclosure. Restatement, comment 160. So classically, caveat emptor. Buyer beware. They don't have a duty to disclose something. But the restatement says non-disclosure without concealment is equivalent to a misrepresentation only in special situations. So if you just don't tell them and they don't find out, but you don't seek to hide it from them, you'll probably be okay. Restatement 161, a person's non-disclosure of a fact known to him is equivalent to an assertion that the fact does not exist in the following cases only. Where he knows that disclosure of the fact is necessary to prevent some previous assertion from being misrepresentation. So you now know that it doesn't work, and you are required. Now your non-disclosure is not correcting something is considered misrepresentation. Where he knows that disclosure of the fact would correct a mistake of the other party as to the basic assumption of what the party is making in the contract, and if non-disclosure of the fact amounts to a failure to act in good faith and in accordance with reasonable standards of fair dealing. So he may not have asserted it, but he knows the party believes something and he knows it's wrong. There's a requirement to speak. Where he knows the disclosure of the fact would correct a mistake as of the other party as to the contents or effect of the writing. So one is what they understand, one is what they're writing, evidencing or embodying agreement in whole or in part, where the other person is entitled to know the fact because of a rational trust or confidence between them. So it's fiduciary duty. Example of non-disclosure, or we're going to say statute as well, because like California has statutes about buying real estate. Example of non-disclosure. A makes to B, a credit rating company, a true statement of his financial condition, intending that its substance be published in to B's subscribers. B summarizes the information and transmits the summary to C, a subscriber. Shortly thereafter, A's financial condition becomes seriously impaired, but he does not disclose this to B. C makes a contract to lend money to A based on that assessment. Is the contract voidable? A's non-disclosure is equivalent to an assertion that his financial condition is not seriously impaired, and that assertion is considered a misrepresentation, because he'd already asserted that it was one way and then it became another, and he needs to correct it. Example of non-disclosure. A, in casual conversation with B, A tells B that a tract of land owned by A contains 30 acres. A knows that it contains only 29 acres, but misstates its area because he does not regard this figure as important. B later offers to buy the tract from A. A does not disclose its true area to B for fear that B will not buy it, and accepts B's offer. So, question, did A's initial statement constitute misrepresentation that rendered the contract voidable? No. A's initial statement was not intended to induce B to purchase the land, therefore it is not fraudulent or material. But did A's failure to disclose that tract was 30 acres upon receiving B's offer to purchase the land render the contract voidable? A's non-disclosure is equivalent to a new assertion that the tract contains 30 acres, and this assertion is a misrepresentation. Okay, how should courts apply restatement 161B? Known mistake as to the basic assumption. In many situations, if one party knows that the other is mistaken as to the basic assumption, he is expected to disclose the fact that would correct the mistake. The mistake must be as to the basic assumption. Nevertheless, a party need not correct all mistakes of the other and is expected only to act in good faith and in accordance with reasonable standards of fair dealing as reflected in prevailing business ethics. A party may, therefore, reasonably expect the other to take normal steps to inform himself and to draw his own conclusions. If the other is indolent, inexperienced, or ignorant, or if his judgment is bad, or he lacks access to adequate information, his adversary is not generally expected to compensate for those deficiencies. A buyer of property, for example, is not ordinarily expected to disclose circumstances that make the property more valuable than the seller supposes. So, if you know there's gold under the land, you don't have to know the seller. But you can't assert that there's nothing, because then you're lying. We're so close, and I hope I still have battery. Okay, Hill v. Jones is the termite case. There were termites under the floor was sloping. They said, are there termites? They said, no. Okay, where the seller of a home knows facts materially affecting the value of property which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. How should courts apply 161B? Question, how much effort should be expected from the buyer? Things that are not readily observable, not within the reach of diligent attention and observation of the buyer, not attainable through normal steps, only where the defects are dangerous. So question, how would you choose the standard? Ethical perspective, the harder the information is to acquire, the higher the duty to disclose. The economic perspective, the higher the cost to acquire the information, the lower the duty to disclose, because it is socially desirable to give parties an incentive to acquire information. The party to whom it is cheaper to acquire the information has a duty to disclose. So the least cost avoider, the party who it is cheaper to acquire the information has the duty to disclose. Fraud in the execution, 166. When representation as a writing justifies formation, if a party's manifestation of assent is induced by the other party's fraudulent misrepresentation as to the contents or effects of a writing evidencing or embodying in whole or in part an agreement, the court, at the request of the recipient, may reform the writing to express the terms the agreement asserted. Elements of fraud. Material misrepresentation of past or existing fact by the party to be charged, which was false, was made with knowledge or in reckless ignorance of falsity, was relied upon by the complaining party, and proximately caused the complaining party injury. Park 100 Investments. So this is, they got, like, the guy was leaving and the agent came out and was like, hey, I need you to sign this. It's the lease agreement. And really it was like a guarantee of like the building forever. That's not totally true, but, and he said, is this the lease agreement? He said, yes. And then he signed it and it wasn't. What about duty to read? Whether one has the right to rely largely on the facts of the case, while a person relying on another's representations must use ordinary care and diligence to guard against fraud, the requirement of reasonable prudence in business transactions is not carried to the extent that the law will ignore an intentional fraud practiced on the unwary. There you go.